Hello everyone and welcome back to the channel. This is Snigdha Mohapatra, a third year student from KIT School of Law and currently an intern under LEXCLIQ. In my recent videos, I have been talking about the trademark law in India. Today's component of trademark is the procedure for registration of a trademark in India. A person may apply for registration of trademark under Section 18 of the Trademarks Act of 1999. A person claiming to be the proprietor of a trademark which is either used or is yet to be proposed or used may apply for the registration by filing an application in writing in the prescribed manner to the registrar appointed under Section 3 of the Act. This application is to be filed in the office of the Trademarks Registry established under Section 5 of the enactment, within whose territorial limits lies the principal place of business of the applicant, but it has to be within the territorial limit of India. In this application, the class of the goods has to be specified according to the International System of Classification of Goods or according to the alphabetical index of classification published by the registrar in accordance with Section 8. There is a provision for filing of a single application for registration of a trademark or for various classes of goods. Now, after the application is made with the registrar, he may refuse the application or may accept it absolutely or subject to such amendments, modifications, or conditions or limitations, if any, as he may think fit or if they are necessary. The grounds for refusal or conditional acceptance of the application have to be recorded in writing for the registrar. Now, various grounds have been established under the Trademarks Act 1999 for refusal. Section 9 and Section 11 give the grounds for refusal of the application. The Section 9 mentions the absolute grounds. Section 11 provides with the relative grounds of refusal of the application. Section 9 of the Trademarks Act 1999 stipulates that the following trademarks will not be registered. First, which are devoid of any distinct character, or second, which consist exclusively of marks or indications which may serve in trade to designate the kind, quality, purpose, values, geographical origin, or the time of production of goods or rendering of services or other characteristics of the goods or service, and third, which consist exclusively of marks or indications which have become customary in the current language or in the bona fide and established practices of the trade. Also, a mark will not be registered as a trademark if it deceives the public or causes confusion, or if it contains or comprises of such matter likely to hurt the religious susceptibilities, or if it contains scandalous or obscene matter, or its use is prohibited under the Emblems and Names Prevention of Improper Use Act of 1950. The provision further provides that a mark will not be registered as a trademark if it consists exclusively of the shape of goods which results from the nature of the goods themselves, or the shape of goods which is necessary to obtain a technical result, or the shape which gives substantial value to the goods. Now, it is pertinent to note here that the section gives protection to a well-known trademark as defined by Section 2, subsection ZG, or a mark which has acquired a distinctive character as a result of use before the date of application, as they may not be refused registration. Trademarks Act 1999, Section 11 states that a trademark may not be registered it because of its identity with an earlier trademark and similarity of goods and services, or secondly, if its similarity to an earlier trademark, or thirdly, the identity or similarity of the goods and services, there is likelihood of confusion. It also provides that a trademark may not be registered which is identical with or similar to an earlier trademark, and which is to be registered for goods and services which are not similar to those for which earlier trademark is registered in the name of a different proprietor, if or to the extent the earlier trademark is a well-known trademark in India. It further provides that a trademark may not be registered if or to the extent that its use in India is liable to be prevented by virtue of any law. It was held in the case of Geep Flashlight Industries Limited versus Registrar of Trademark that even if the appellant's proposed trademark satisfies the conditions under the Act, the appellant is not entitled as a matter of right to the registration of the trademark. It is open to the registrar to decline the register of the appellant's trademark. Now, after the application and the acceptance where absolutely or conditionally it has been accepted, and even in certain circumstances before the acceptance, the registrar causes the advertisement of the application so as to afford to the public the opportunity to oppose the registration of the mark. Now, the next step in the registration comes the opposition. After the advertisement, any person may, within 3 months from the date of the advertisement, give notice of its opposition to the registration application. The registrar serves the copy of this notice to the applicant, who has to, within 2 months of receiving it, file a counter statement and grounds on which he relies for its application of registration, failing which his application is deemed to be abandoned. Now, the final stage is when the procedure is completed and the registrar, by virtue of Section 23, registers the trademark and the certificate of registration is issued to the applicant. The date of registration is the date on which the application for the registration was made. Now, the period of the registration of trademark is 10 years, after which it may be renewed from time to time. Hence, as compared to other forms of intellectual property, in one sense, trademark may be protected for perpetuity subject only to the conditions that it is used and renewed periodically. It is interesting to note that the first trademark registered in United Kingdom under number 1 of 1876, consisting of a red equilateral triangle in respect of alcoholic beverages, is still in force. Now, thank you so much for watching the video. Please subscribe to the channel for further updates.